Oh yeah, at the Heritage Bookstore or on our website. It's Your Will Be Done by Arthur A. Cresby, and that's C-H-R-E-S-B-Y. He was a parliamentarian in the lower house of the federal parliament back in the 1920s.
Was that Arthur H?
Arthur A.
One of the ways up there that people are talking about laws of England and how they.
So every law in force in colony which has become or becomes a state and relating to any matter within the powers of the Parliament of the Commonwealth shall, subject to the Constitution, continue in force in the state. And until provision is made in that behalf by the Parliament of the Commonwealth, the Parliament of the state shall have such powers of alteration and repeal in respect of any such law of Parliament as the Parliament of the colony had until the colony became a state.
They're the key words, as the Parliament of the colony. The Parliament of the colony, prior to Federation, could not make any law repugnant to the law of England.
So, just you were mentioning before about the constable at the academy.
Yep.
I was watching something on YouTube last night by a chap in England from the British Constitution Group.
Yep.
And he was saying that he's taking cases to the High Court in England to show the magistrates in the lower courts that they're being told untruths.
Yep.
Is that the kind of thing you're talking about with the constable? He's been told that the Constitution doesn't have any effect, but it does. He's been lied to.
Yeah, well, in effect, what they've done, they've incorporated the sheriff, they've incorporated the police, they've turned them into entities that are acting under a statutory authority which is outside the laws of the land. And they make them believe that this is the law and only the law. They put blinkers on.
But it's not.
It is not. Okay, and the only way they can get away with that is to hide this from them and hide the interpretation from them and keep the interpretation from them in respect to them making their own interpretation. Okay, again, we are like sheep. We are very much like sheep. We've got this leash lying out there ready for anyone to grab and lead us wherever they want. And this is particularly the case of those in the public service and in universities. So our lawyers are just as guilty.
To take that one step further, someone who's familiar with the Constitution and is subject to harassment by a police officer who's none the wiser because he's been told otherwise.
He's none the wiser.
He can be held personally responsible for the acts that he commits.
Absolutely, under the law of tort.
Now, how are they enforced in a court of law? It seems to be not.
Yeah, it is getting worse because the courts are distancing themselves further and further from this because they're realising that they are in deep trouble.
So you're looking at really, you get it to like, you get it to your lower level courts. And as soon as you realise that they're not going to enforce the Constitution, you have to basically say, no, I'm appealing this to the Supreme Court to take a look.
Yeah, it really becomes a directions hearing. If it comes to a point where you're challenging the jurisdiction of the court, like for instance, a good example is Section 100 of the Magistrates Court Act here in Victoria in 1989. Section 100 is clearly headed jurisdiction. Okay. Now, Section 100 says that Magistrates Court does not have jurisdiction with respect to anyone challenging any legislation that the prosecution is relying on or any royal prerogative. Okay, the Magistrates Court is bound purely by hearing matters by consent regarding property, and that's it. So it becomes a directions hearing. So when you get to the Magistrates Court and you're not happy with that legislation, the first thing you do is establish that the court is being asked to direct this into a court of competent jurisdiction.
So by rights, everybody did this. There'd be no magistrates courts at all.
No, the magistrates courts are there. They have a purpose. They're there for people who do consent to just getting the matter done.
I was saying if people were aware and they did not consent, there'd be no need for any court.
Oh, absolutely, but that's You know,
Just to make
until
money.
the general public are educated to this standard, then that just won't happen. But magistrates' courts are a creature that was created back in King Henry VIII's time with respect to getting a matter dealt with quickly and getting it out. But they're beyond that capacity at the moment. When they're confronted with a consent problem, they just overrule and they just basically say, too bad, mate, you're going to wear this, too bad. And this is where they're going wrong.
Isn't it just admiralty law that they use in the magistrates' court, law of the sea, isn't it?
Not really, it's administrative law. Admiralty law is a creature that exists purely in that jurisdiction.
Yeah.
It was actually Malcolm Fraser's time, they brought in administrative law, and it comes in the States under the Administrative Law Act. Okay, so that's their foundation as such. And it's up to us to become aware of that and then remove our consent or ask that the court direct this into a court of common jurisdiction. And under the Civil Procedure Act, it can go straight up into the Court of Appeal, the Supreme Court. If it's a jury matter, it can go to the county court. The county court can exercise this jurisdiction, although in my last experience in the county court, probably about a month ago, I was told quite bluntly that this is a state court and not a Chapter 3 court. So in effect I said to the judge at the time, well, if you're deeming this to be a state court, then it's a star chamber. He said, oh no, this is not a star chamber. So he knew what I was talking about.
What is the definition of a star chamber?
Okay.
Star chamber is a court that was risen by King Charles back in 1629. King Charles imposed a compulsory tax on the people of England, a tonnage and poundage tax. And to enforce this tax, here we go. A star chamber court is defined in Black's Law Dictionary. An English court having broad civil and criminal jurisdiction, King's discretion, and noted for its secretive, arbitrary, and oppressive procedures. Ring any bells for anyone who's been including a compulsory self-incrimination, inquisitorial investigation, and the absence of juries.
It's a magistrates' court.
So that describes our magistrates' court and county courts down to an excellent time. Supreme Court's become the same pretty much.
Just before you were saying that if you get like a final something from the magistrates' court and you say, look, you don't have any jurisdiction over me, and you're saying they just go, bad luck, mate,
Yep.
you're getting fined. Is that what happened? And then what, you just ignore it?
No, you've got an appeal right straight out of the magistrates' court to the county court.
Make the judge swear to his oath.
Well, yeah, the oath does take place, but in chambers, not in front of them. We have had a variation of reactions to appeals. In fact, back when Steve Bracks was Premier, they actually were that frustrated by the amount of appeals from the magistrates' court. Parliament was seriously thinking about cutting off that appeal right. Rather than, this is a case of throwing the baby out with the bathwater. They really got to confront the fact, why are people appealing? Wake up. So we've really got to stand up and put our cases into the county court. If you have and coming back to a purely constitutional sense, Section 40 of the Judiciary Act gives us the right to appeal a matter if it's on constitutional grounds straight to the High Court, out of that magistrates' court. Section 40 of the Judiciary Act 1903. Okay. So they have to give a very good reason why they're knocking that back. especially if you establish the constitutional grounds for which you rely. Now, Section 109 is a classic, okay, and it's been used more times than I can poke a stick at in the last 100 years. You can appeal it straight to the county court, but now they make you sign a whole bunch of documents that pretty much give you, put you in a position where you're cornered into accepting whatever the county court puts out, and most of the time it will be worse than whatever the magistrate does. And of course they're always urging you to get legal representation. We had a case up in Albury, or Wodonga, where this gentleman was charged for not wearing a seatbelt. And he was wearing a seatbelt, it was just that the police officer was unable to see clearly, but he decided to make this stick. This gentleman appealed it. Oh, he said, I want to take this into court. So he did, he went into court and he said, I'm challenging the legislation that the prosecution is relying on and the regulations. I'm not consenting to this. And because I'm challenging it, I need this to go into a court of competent jurisdiction. The magistrate laughed at him and said, no, forget that, mate. And for using that sort of defence, I'm going to take away your licence for a month. How dare you bring up that sort of rubbish in this court? Now, he walked out of the courtroom, rang me, he said, what do I do? And I said, well, appeal it straight away. So he went straight to the registrar's counter and he appealed. He put an application to appeal. And the registrar looked at him and said, mate, you've lost your licence for a month, get over it and get out of here. He then rang me back and he said, well, I do. The registrar is refusing to allow the appeal. And I said, that's fine. Just go back to the registrar and say, I need your name, because I'm going to charge you in Melbourne courts for attempting to pervert the judicial power. Straight away, the registrar brought the paperwork out for the appeal. It does work. And he got his appeal. But the police have been harassing him every day since. And they've been trying to pull him over for unlicensed driving since. And this is just wrong. It is wrong because, but unfortunately he was by himself. Now, what we do here in this group is, because we are seen as radicals by some, we ask that whenever it does come time to one of us to go into these star chambers and state our case, that we ask people for support. To come along and support those people in their courtroom. And that has been quite successful lately. In fact, the other day, I'll ask Kathy to come up and report on this, but there's a lady here who's been railroaded by absolutely draconian legislation. And she's appealed it out of the magistrates court into the county court. That hearing was the other day, and the room was probably about 20 of us there, I think. But it has an impact on the judge. Okay, they can't get away with blue murder like they have been for too many years.
Yes, they can.
Well, they certainly try, and in my experience, when there has been a large group of people there, they do hesitate, because they know that we know the law and we're prepared to take that next step. We're not prepared to get up and throw eggs at them or whatever. We'll do this the right way.
I don't want to make the presentation any harder, so if you don't want to answer this, just say so.
Just go here.
So much technical presentations that are on YouTube at the moment by people in Canada like Dan Clifford, facts like Winston Stroud, where they're applying commercial lens to individuals.
In America it's fantastic. In Canada it works. In Australia it's different. We have a very unique system of law here, because we have inherited not only